Testing, testing.
Your microphone's on. In compliance with the Open Public Meetings Act of 1975, adequate notice of this meeting has been provided. If any member has reason to believe this meeting is being held in violation of this act, they should state so at this time. Please stand for the Pledge of Allegiance.
Mrs. Werner,
Here.
Mr. Venuto,
Here.
Mr. Ledwin.
Here.
Mrs. Notch.
Here.
Ms. Sheehan,
Here.
Mr. Walsh, Mr. Zexer,
Here.
Mr. Yeager,
Here.
Ms. Stevenson.
Here.
Thank you.
Okay, we have two resolutions to approve. The first one is Gary and Miriam Waxman, 931 Corgi Street. Could we have that motion?
I make the motion.
I'll second.
Ms. Sheehan motions, Mrs. Notch seconds. Mr. Ledwin?
Abstain.
Mrs. Notch?
Yes.
Ms. Sheehan?
Yes.
Mr. Zexer?
Yes.
Mr. Yeager?
Abstain.
Thank you.
I think.
Mr.
I wasn't here, right?
Okay, yes. Mr. Venuto?
Abstain.
Yeah.
Mrs. Werner?
Yes.
Thank you.
Our second resolution is Brian and Victoria O'Connor, 1226 Lafayette Street. Somebody make that motion?
I'll make the motion.
I'll second.
Mr. Zexer motions, Ms. Sheehan seconds. Mr. Ledwin?
Abstain.
Mrs. Notch?
Yes.
Ms. Sheehan?
Yes.
Mr. Zexer?
Yes.
Mr. Yeager?
Abstain.
Mr. Venuto?
Abstain.
Mrs. Werner?
Yes.
Thank you.
Yes, Sam wasn't either.
Next, we have the minutes of the June 26, 2025 meeting. Can we have a motion?
I'll make the motion.
I'll second.
Mrs. Notch motions, Ms. Sheehan seconds. Mr. Ledwin?
Abstain.
Mrs. Notch?
Yes.
Ms. Sheehan?
Yes.
Mr. Zexer?
Yes.
Mr. Yeager?
Abstain.
Mr. Venuto?
Abstain.
Mrs. Werner?
Yes.
Thank you.
Okay, our first application this evening is Theodore and Patricia Underko, 815 Columbia Avenue.
Okay, good evening, Madam Chair, board members. My name is Ron Gelzunas, appearing on behalf of Ted and Patricia Anderko. Mr. Anderko is there to my left in a pink shirt. The property, of course, is 815 Columbia Avenue. If you recall, we have a lot of new members here. This very same application was before this board in February of 2021 when it was approved. The approval, unfortunately, was never acted on. Since then, in 2022, Ordinance 52590, it was enacted, and that put an expiration date on the approval, which has since been exceeded. So the Anderkos are now making the very same application for the same relief. The plans you are looking at are the same plans that were before this board in 2021, if you notice the date. And it's basically the same application as well. I just updated it and modified it with some new explanation. We aim to demonstrate that the relief granted in 2021 is still appropriate, based on the fact that there have not been any substantive changes in the area, in the neighborhood, on the property, or to the zoning ordinances. Our witness this evening is Mr. Mark de Blasio, our engineer. He was also our witness back in 2021. Of course, Mr. Ted Anderko. If we could have them both sworn in case if you have any questions for Mr. Anderko.
Okay, I'm Russell Springer, board engineer. Do each of you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I'll
I do. Mark, if you would just briefly place your credentials on the record.
Sure, I'm a graduate of Rutgers University College of Engineering. I'm a licensed professional engineer in 11 states, including the state of New Jersey, and I'm a licensed New Jersey professional. I have 26 years of civil and engineering experience and have been before this board, I guess, 4 or 5 years ago.
Okay. Accepted.
Accepted, thank you. Mark, why don't you take us through the proposal again, the conditions on site, and how they relate to how they were in 2021 as well, if you could point out if there were any changed circumstances.
So as Mr. Gelzunas had indicated, there has been no changes since this application was
Excuse me,
presented to the board previously.
please, thank you.
Okay, gotcha. Mr. Anderko, the applicant, is proposing an expansion of the main principal structure that's located up along Columbia Avenue, with an expansion towards the rear, heading towards Page Street. There's additional stormwater recharge that we're providing as part of the project, which was consistent with the original conditions. Mr. Endurko at the time had received preliminary HPC approval for the project, and his goal is to add an additional approximately 350 square foot of additional building space that will add 2 additional bedrooms to that principal structure located along Columbia Avenue.
You want to keep going? Or?
Keep going? Okay.
Is your testimony likely to be any different than what's set forth in Resolution 0325421?
Negative.
If everyone's reviewed that, maybe you could just see if anybody has any questions about his prior testimony.
Resolution was attached to the application as an
Exhibit A.
It is in here.
Is it a long
Yes.
paragraph too with the resolution that describes his testimony?
If I could also add, Mr. King, that,
Add anything you want, I was just trying to spare
Okay.
you repeating everything.
so in addition to no changes in the proposal, there's photographs in the application that show there's been no other changes to the site since we were here before you as well. So there's no proposed changes, and there've been no alterations or existing changes that would change the nature of the original
Are
approval.
you aware of any changes in the ordinance that affect the project since 2021, besides the one that made you come here tonight?
Not to my knowledge, no.
Only a drainage ordinance, but I'm told that we conform with that.
I'll go through that.
That was the only change. So I just want to go through a brief, this is a variance for expansion of a non-conforming use. Just want to make
Yes.
clear to the board that
Can you
that
move the
non-
mic closer?
that nonconformity is a garage that was permitted to be converted into an accessory structure.
Correct.
And there's no construction or no alteration to that proposed.
Correct.
That would change its configuration.
So the structure that was in the rear of the property, which was once a garage and legally converted to a cottage, which, in my opinion, causes the project to be non-conforming. There's no revisions or alterations to that cottage.
And even though there's that accessory cottage on the property and the expansion we're talking about, the floor area ratio is proposed at, I think it's .45, which is greatly under what's permitted at .65.
Yes, so the FAR for this zone, which is the RS zone, is .65, and we're at .45.
Other than that, we're really talking about a side yard setback, a vertical intrusion into the side yard setback, because the expansion is within the same footprint of the existing structure.
Correct.
And that results because the lot is tapered, it gets narrower towards the back, so it's only that back corner,
It's a trapezoid, yes.
a trapezoid.
Trapezoid.
Okay. So that creates an unusual circumstance. I don't recall if this was granted under the C1 or the C2, but would it meet either of those criteria?
It would.
So, and with all that in mind, you don't see any negative impact to the area or neighborhood or adjoining properties?
Correct.
And you don't see any substantial detriment to the zone plan or the zoning ordinance?
That's correct.
And the other improvements to the property, you mentioned the stormwater drainage system. This is going to be a renovation that brings this more into conformance with the HPC guidelines.
Correct. There are various aspects of the existing structure that do not conform to the HPC guidelines as they exist today, and Mr. Endurko's proposal will make them conforming.
There was also the front steps protruded over the property line into the public right-of-way, and in 2021, they were going to be moved back to be solely on the property.
That's correct.
So these are all aspects of the proposal that are going to advance get this property closer into conformance and better the overall condition of the property.
Yes, those are the positive benefits of the project, yes.
And that advances the historic zone as well. That's a special reason, getting closer to.
Can you put your mic closer, Mr. Galzunas? You turn your head and then it doesn't get near the mic. Sorry. And then you're facing that way and I can't hear.
So that's another special reason,
Yes,
as long as a more desirable visual environment.
correct.
Okay. Does anyone have any questions on the plans or what was approved in 2021?
I just have one quick question.
Sure.
When it says habitable area, does that include the cottage also, along with the house?
Yes.
Okay.
And if I could add, Mr. Galzunis, the report that was provided by Mr. Hurlis, we don't take any exception to his conditions and comments, and we will work diligently with him to perfect the project, should you approve it.
I have a question. You have conceptual approval from HPC, but that was 2019. Is that still valid?
I don't think it's changed, but he certainly has to go back to HPC, and I've let him know that it's in his interest to have them take a look at this again. He has other things he wants to do as well. There's going to be new shingles on the accessory structure, so he has to go back for that. So they'll have a second bite at the apple to satisfy them. And he'll have to go back for final as well.
There may also have been changes to the guidelines since 2019. They change more frequently.
Right, so he'll comply with whatever the HPC requires.
Seems like it'd be good for Mr. Hurlis to give his report.
Certainly, I'd like to summarize my July 3rd, 2025 review memorandum for this application. This is virtually the same memo that I had the last time you guys approved this. So I'm just going to take you through it quickly. If there's any questions, please let me know. Just with regards to the completeness review, items 5, 13, and 18, I did recommend we waive them at this point, but those should be conditions of approval. As the applicant indicated, they got this approval before but never perfected the plan. So there's been no compliance approval, so the plans were never revised to meet the conditions in this report. We're dealing with the same plans that we dealt with at the last time we heard this. Item number 28 is design calculations. I support that waiver. They did provide a drainage design. I did have some specific drainage comments in my report. They will be addressed during compliance review, so I've recommended waiving that, and also recommended waiving the landscaping plan requirement because there's virtually no changes going on with that, and therefore recommended deeming this application complete. Mr. King, I know you used my report as the basis for your resolutions. There is a typo, and Mr. de Blasio's testimony indicated that the floor area ratio in the RS district is 0.65. My report indicates it's 0.45. Mr. de Blasio is correct in there, and that is a typo. So that should be corrected. And they're far beneath what they're permitted to do on that lot, even including the cottage. So this is a request for a D variance because there are two principal structures or principal uses on the lot. Essentially, the cottage at the rear qualifies as another single-family dwelling. That's not being touched. There's the addition only to the front structure, but because there's two, if you touch any of them, it triggers that D variance. Okay, so there's a use variance. The lot size per family is not met because there's two family structures on that lot, and the lot is undersized. The building setback line on Columbia Avenue has a encroachment in the existing condition. They're making that better. They're pulling it out of the right-of-way, and it will have a 0-foot setback where 0.3 feet encroaches into the right-of-way. The lot width and lot frontage requirements are not met. This is an existing non-conforming condition. And the side yard setback, 8 foot is required, 1.3 foot is proposed, and that's measured to the building improvements. So really, the two things that are being changed by this addition on the structure are the building setback line in the front is getting better because of these improvements, and then the side yard setback on the one side of the principal structure is remaining at 1.3 feet, but that is an expansion within that setback. So those are the variances that you're going to be addressing. With regards to my general review comments, all of these were conditions of the original approval.
Craig?
They're specific with...
Before you, can I get a question about your chart real quick?
Sure. I'll go back.
I'm sorry, before you moved on, that's.
Yep.
Now, there's going to be 2 extra bedrooms put in the house, so it's 4 bedrooms and 2 in the cottage, correct?
There's 4 bedrooms and 2 in a cottage, okay?
But this only says 2 and 2, right?
So the requirements, a third parking space is not triggered under the residential site improvement standards until you hit a 5th bedroom. So they can go up to 4 bedrooms and only be required to provide 2 parking spaces. So the requirement for dwelling number 1 is 2.
Uh-huh.
And then the dwelling number 2, the cottage, has a requirement of 2 spaces. So-
Okay.
So that's, the calculation
So
is
there's
4, they have 4 on site, it's a conforming situation.
That's why I want to make sure there was 4 parkings on site.
Yeah.
Okay.
Yeah, when they hit that 5th bedroom, it would trigger an additional parking space.
So it's
They're
just,
not-
so it's just counted 4 and 2 is how they count it? 4 bedrooms in the main house and 2 bedrooms in the cottage?
Right. But
Which is-
we look at each individually under
separate.
the residential site improvement standards, and we add those up, and the total is 4.
Well, if the number was 6, you would only need how many?
If the number,
If the total bedrooms were 6, how many?
It would still be 4.
no, you have to calculate each one
I
separately.
know, but even if you did it the other way, I'm trying to assuage
Yeah.
our concerns.
Yeah,
If you
yeah.
Yeah,
applied
there's-
6,
Yeah.
it'd still only be 3.
Even if you total of the bedrooms, you still would not get to another required parking space.
Right, the 4 is covered. That's all I want. Thank you.
Well, if we consider them together, we could get rid of the D variance then.
Okay, so the general review comments, I'm not going to go through these, we've already been through them. A lot of them are technical in nature, and just, these are the things that need to be addressed when they provide compliance plans for review. The only thing that I think has changed is with regards to Chapter 525. Since this application was approved, there has been an amendment to that, Chapter 525, which is our minimum stormwater management and grading requirements. I have reviewed that, and this plan is consistent with that, provided that they address the other specific drainage comments that are in my report. So based on that, I support the application, and so long as they address those as conditions of approval. It should be noted that we did receive fire department recommended approval dated 7/14/25, no comments. Public Works Department recommended approval with no comments dated 7/11/25. Shade Tree Commission recommended approval with no comments dated, I don't see the date, oh, there it is, July 11th, 2025. And that's a summary of my report, and I'm happy to answer any questions the board has.
So I want to open it up. Okay. At this time, we'll open it up to any comments from the public within 200 feet of the structure. Anyone beyond 200 feet that wishes to make a comment? Closed to the public. Do you have anything else you want to say?
No, I think that's it. We can see here that this is going to be a great a renovation. It's going to make the property much better, much more in conformance with the HPC guidelines. It was appropriate back in 2021, and as we can see from the testimony and from your knowledge of the zoning ordinance, nothing has changed. The pictures that were provided, I went back, I stood in the same spot as I did in 2021 and tried to get the exact same angle and exact same picture. Not as easy as it sounds to do, but I did that, and I put them side by side, and you could even see that the neighbor has the same car he had in 2021, but it's a different color, and it's parked in the same spot. So that's, just tells you nothing's changed, really. So this will be overall a betterment of the streetscape and the historic district and the city overall.
Okay, thank you.
I make a motion to make a resolution?
The motion I recommend be made, but how you vote is up to you. It's a motion to grant the variances outlined by the board engineer on page 4, 1 through 5. Recall that one of them is a use variance of this project. It's the kind of like the lower level use variance. It's an expansion of a non-conforming use. So you have to conclude that it can accommodate the expansion without a substantial impact, a negative impact on the zone plan and zoning ordinance, but they require 5 affirmative votes in order to succeed. The applicant has incorporated by reference the testimony put forth in the prior resolution, which was 0325-2021. So if you do grant it, it's my intention to incorporate by reference the findings of fact and conclusions of law in that resolution. But if you feel differently than was set forth in that resolution, I ask you to say that in your decision. Okay? Subject to the conditions outlined by the board engineer.
We have that motion?
I'll make the motion.
Okay.
Second.
Okay, was that Mr. Zexer motion and Mr. Ledwin seconded? Correct? Okay. Mr. Zexer motions, Mr. Ledwin seconds. Mr. Ledwin?
Yes.
Mrs. Notch?
Yes.
Ms. Sheehan?
Yes?
Mr. Zexer?
Yes.
Mr. Yeager?
Yes.
Mr. Venuto?
Yes.
Mrs. Werner?
Yes.
Thank you.
Thank you, Madam Chair, board members, for your time this evening.
All right, thank you. Thank you, Mr. Kazunas. Blasio?
Well, okay, our next application is SP Cape May Marina LLC, 124 Roseman's Lane. And this,
Are we going to hear these in conjunction? Are we going to hear both of these at the same time?
I think we're going to hear from their,
Counsel, do you want us to hear these together, or do you want to hear us separate? I'll have them vote separate if you want, but I mean, to do the testimony.
are they not interrelated, and just because of the ownership is why we have 2 applications? Okay.
Madam Chair, what are your thoughts on it?
we'll be voting on each section separately.
You'll
though.
vote
Yes.
separately, but
Okay.
they're just going to describe the project
The project,
in
okay.
a
All
holistic
right.
way, I think, and
Okay. So we're also going to look at the Cape May Paddle Club, 124 Roseman's Lane. Okay.
Good evening, Madam Chair.
Can you move that mic closer? Thank you very much.
Madam Chair,
one thing, Counsel, I'm also going to do, we're going to do 2 separate decisions. Not just
yes,
2 separate votes, but 2 separate decisions. That way,
Yes.
if one goes a different way or whatever, you're not stuck with both of them being delayed. So we're going to,
That's-
I'm going to do 2 resolutions, or just hearing both applications at the same time.
that's
Okay.
perfectly acceptable, Mr. King. Board members, Mr. Hurlis, Mr. King, my name is William Kaufman. I'm an attorney with the firm of Nemad, Davis, and Goldstein in Egg Harbor Township, and I'm here this evening representing the 2 appellants in these matters, one being SP Cape May Marina LLC, the other being the Cape May Paddle Club, which is a New Jersey nonprofit corporation. With me this evening are Mr. Sean Scarborough. Mr. Scarborough is the managing member of the Marina, and I'll refer to it as the Marina, and Mr. Scarborough is also the executive officer and trustee in the Cape May Paddle Club. So I indicated that the appellants here are the Cape May Marina and the Cape May Paddle Club. The property involved is Block 1061, Lot 101.05, as the chair indicated, commonly known as 124 Roseman's Lane. The zoning is C6 Marina District. The present use of the property is a marina and a 3-story clubhouse and marina office building. I would note that the use of the approvals for that building date back to at least 2004, based on my review of prior planning board approvals. In 2022, the club space was reduced. The marina appeared before the planning board and received approvals to treat the third floor as a boatel. Mr. Hurlis was the board engineer in that and has knowledge of that and can answer any questions that you may have regarding that. But we're not here this evening to relitigate or revisit any prior approvals for this property. What we have here tonight is something that maybe doesn't happen all that often, is an appeal of an administrative decision, which is one of your powers under Section 70 is to review decisions of the zoning official. And in this case, your ordinances are very interesting because your ordinances, I looked up, or I did a word search in your ordinances for the term zoning permit, and they appear 3 times. And one is in connection with stormwater management, the other is in connection with something called an event house, and the third is in connection with electric vehicles. Your ordinances, however, suggests that to get a building permit, you also need a zoning permit. And why would we need a building permit? Because what we are proposing is we're taking the first floor of the clubhouse and we have excess storage space and we want to convert that space into a dining area for the club members because we have a dining area outside by the pool deck, and you have the plans that show that. And we also wanted to add a roof over the pre-existing concrete porch at the entranceway where the club members go in and out of the first floor club area. So, assuming that in order to get a building permit, you need a zoning permit, we made application for a zoning permit for the roof, and that was applied for by the marina, and we made application for the dining area on the interior, and that was a zoning permit application by the paddle club. Those 2 applications were denied. Now, with regard to the denial of those 2 applications, there's something interesting about them. Both of them, and you have them in your materials, indicate that, and I'll read them both because it's very important. With regard to the Cape May Paddle Club, it says, your request is hereby denied based upon the following requirements. Site plan approval required. And if you look at the denial of the application for the zoning permit for the roof that was filed by the paddle club, it pretty much says the same thing. Your request is hereby denied based upon the following requirements. Per chapter 417, site plan approval is required. So what happened here is that the zoning official denied 2 zoning permits based on site plan considerations. And I would suggest to you, and I would argue to you, and I would advocate that it is improper for the zoning official to deny a zoning permit application on site plan considerations. And why do I say that? And I say that because a zoning permit is not defined in your ordinances, and when something's not defined in your ordinance, it's always good to turn to the municipal land use law, and a zoning permit is defined in the municipal land use law. And I will read that definition because it's important. And it's in section 7.
Just ask a quick question.
Sure.
Is this argument that you're making in your applications?
Well, this is an argument that I'm making based on the face of the.
I don't mind you making the argument, and it may be a perfectly fine argument. I just feel like I'm hearing it for the first time.
You probably are.
Okay,
Yeah,
and you're going to have to
yeah.
slow down, because if you
Okay.
read stuff, I got
Okay.
it'd be helpful if I,
So-
what you were going to.
Okay.
Big
The
argument for
the argument is going to be, we are prepared to tell you why we don't need site plan application. Mr. Scarborough and Mr. Shula are here and are prepared to present that evidence. However, I'm suggesting to you that you don't even need to get to their testimony because you can find that the zoning official had no authority under the municipal land use law to deny a zoning permit application on site plan considerations.
Who does?
Who does would be, you go apply for your construction permit, and if the construction official, who you have to have all of your approvals in line, and if the construction official says, no, I'm not giving you a construction permit because you need site plan approval, then you appeal that decision to the Construction Board of
What
Appeals.
if it's the desk across from him and says, yo, Steve, do they need, Steve's the zoning official, and the construction official, Bob, and looks across the desk and says, Steve, do they need a site plan for this? And the zoning official says, oh, yeah, they need a site plan. And then the construction official says, you need a site plan. I mean, I don't
Yeah.
understand what the difference is.
Yeah. Well, because the forum where the appeal is heard would be a different forum. It would be the Construction Board of Appeals at that point, not this
Do
forum.
you think the decision whether or not a project in our town needs to get a site plan review is something the construction official, the Construction Board of Appeals would hear under the UCC?
Because that's where, yes, because that's where appeals from construction official decisions go.
Did you appeal to them?
We weren't able to get a construction permit because we were denied a zoning permit on improper grounds.
But don't you appeal the denial of a construction permit to the construction?
We didn't apply for a construction permit because we don't have the zoning permit. The zoning permit is the precondition to getting the construction permit.
Okay, is there a case that says that the zoning official can't tell you you need a site?
Well, let's read the definition. The definition in Section 8 is this. Zoning permit means a document signed by the administrative officer, number one, which is required by ordinance as a condition precedent to the commencement of a use or the erection, construction, alteration, conversion, or installation of a structure or a building. So if you need to get if your ordinance requires it, it goes to the administrative officer in charge. And then it goes, which would be the zoning official. And then it goes on to say, and two, which acknowledges that such use, structure, or building complies with the provisions of the municipal zoning ordinance or variance therefrom duly authorized by a municipal agency pursuant to sections 47 and 60, which are C variances by the planning board and C and D variances by the zoning board. So the definition of a zoning permit limits the consideration of the zoning official to the zoning ordinance. It specifically says zoning ordinance. You have two ordinances. You have a zoning ordinance and you have a site plan ordinance. The zoning official cannot base a denial of a zoning permit on site plan considerations. On the face of it, you could, without hearing any evidence whatsoever, overrule the zoning official on those grounds alone.
I am unprepared for that argument. My board is unprepared for that argument. I think we should adjourn so that I can research that, because that's not anywhere in this paperwork, and I have no idea if you're right or wrong. I mean, it's zoning permit, not zoning officials, the definition. My general understanding is that when you make an application for a development project of any kind, it's reviewed for two things, construction and zoning. If it doesn't pass either one of those, it gets denied. And I don't know who in the world would look at whether something needs site plan approval for ingress and egress and lighting and all the things that go with site plan, if not the zoning official. That's just king on zoning. I've read nothing on that. But, Mr. Hurlis, you're a licensed planner. Who reviews whether something is a change in use? I mean, our
The zoning
site plan is
official.
triggered by a change in use. So isn't well, then you're saying the zoning official isn't supposed to do that?
No, the zoning official is charged with the duty in looking, when the zoning official gets
Wait
a
minute,
zoning,
wait. I thought you just said that the zoning official can only deal with the zoning ordinance.
correct.
Okay, but the thing that triggers site plan review, a change in use, is in the site plan ordinance, isn't it?
It's in the site plan ordinance, that's
So,
correct.
but your argument is that the change in use is determined by the construction official, not the zoning official?
No, by
In
the
other
zoning
words, The
official.
zoning official can look at things in the site plan ordinance.
They have to look at the use. It's
I'm not
similar
gonna figure this
to.
out tonight. I'm not going to do it. I'm not going to make something that we're going to get reversed on tonight on a new argument that I've heard nothing about. I need time to review that. It doesn't make sense to me. If it was something easy and I could say, oh, yeah, that's consistent with my 30 years of zoning experience, I would say, okay, I can deal with that. But if you're coming in to argue that a zoning official can't decide if something needs site plan approval as a matter of law, I am not letting them vote on that because it's just a waste of time. I'll research it and I'll come back and I'll give my board my best answer on that because they're going to look at me for the answer on that because none of them know.
Well, I can tell you that we're not going to waive the argument, so.
I'm not asking you
I got it. So we're prepared tonight to proceed with, if you want to go beyond that.
I want you to preserve all of your arguments, but it's a brand-new argument that wasn't the basis for the appeal. The basis for the appeal, I thought, was that you didn't need site plan review because it was not a change in use. That's what I thought you were going to come in and talk about. That's what it seemed to imply. But to say that there's some statutory inability of the zoning officer to make the decision he made, totally new, not going to rule on that tonight. I'm not prepared.
Yeah, it is that, and I'm saying that, and if you, the board, because ultimately it's your decision, if you disagree with my position on that regard and my argument in that regard, we're prepared to tell you why we're exempt from site plan review. We'll do
I fully
that.
admit, you may be
Yeah.
totally right.
I got it. Yeah.
Okay? I have no idea. The stuff you're saying to me is not making sense to me, but the law is contrary to my understanding. It happens about once a month, where something that I really think is the law turns out to be different.
All right.
So I admit this could be the one this month. So I need time to review that, because that's,
All I'm saying is this. The zoning official, when the zoning official receives an application for a zoning permit, is confined by the zoning ordinance.
I know, but we just agreed that the change in use that's in our site plan ordinance is something the zoning official decides.
Your site plan ordinance does not deal with changes of use. Your site plan ordinance deals with site plan considerations, not use.
Separate chapter.
It's a separate chapter.
So we have a zoning
Absolutely.
ordinance, we have a chapter for subdivisions, we have a chapter for site plans.
Okay. And where is the language that says when site plan is triggered?
In the site plan.
That's
chapter.
my point. And that is triggered by a change in use.
Not necessarily. It
No.
could
That's
be.
one of the things
One
that
of the
triggers
things, yeah.
site plan.
There's number of things that could trigger.
Right, but that's one of the things. And we've agreed that the zoning officer is the appropriate one to decide if it's a change in use. Therefore, the zoning officer is reading the site plan ordinance. But you're telling me that somehow statutorily, the zoning officer can't make a decision about the site plan ordinance because he's limited to the zoning ordinance. So I already see something that makes me doubt the validity of the argument, but I'm not going to give advice on that tonight. I'm just not prepared for that.
And I'm pointing directly to the denial of the applications. The zoning official did not cite the zoning ordinance.
Yeah, he may, I think he cited the right thing. I think he said, look, you guys are taking something that was storage and you're making it a mini restaurant for members. That sounds like a change in use. I can tell you that my view of it is that it has different parking analysis. When you go from a members' meeting room, that is the same humans who live in the facility are going to go there and chat about stuff, that's one use. When you make it into a restaurant with a serving liquor, where by definition, you almost have to have an employee there, a meeting room doesn't require employees. Serving liquor requires employees. We require a parking space for every employee. So to me, it sounds like you might, you might need, it might be a change in use that require, but I don't know, I'm not prejudging that. I'm just telling you the argument you're making that you want to preserve, I'm not smart enough to address tonight.
And in this particular case, I would just point out that your zoning ordinance allows clubs to have a dining facility with liquor licenses.
It does.
Yes.
It absolutely does.
And that's what the zoning official should have been looking at.
That's why you-
not the site plan ordinance.
You don't need a use variance. You just have something that affects parking, and that would be a site plan issue. Once you start doing things that has a different, Cape May is driven by parking. Okay, parking.
I got it. I was the solicitor of
You're
North
wild.
Wildwood
You
for
know that.
20 years.
And that's why restaurants have certain calculations, hotels have different calculations, even things within the same district that sound like similar uses have different analyses. So when you start doing things like serving liquor, you're going to have employees. I mean, one. Or is it just going to be, I mean, it's a restaurant, that's done by table. So,
No,
I
it's a
mean,
dining area for members. It's no different than what already occurs on site. The licensure of the premises, it basically is irrelevant.
I don't vote. I'm not going to tell them how to vote on that. I don't have strong feelings about it. It may be that they conclude that having members meet there and having them drinks there really doesn't affect site plan analysis, and they may agree with you. That sounds like that's a rational conclusion. I have no issue with that. I'm simply pointing out that it was appropriate for in my opinion, the zoning official to say, wait, this sounds site planning to me, okay? But because it's on the line for me too. And that's a perfectly reasonable thing, and I think we were all prepared to discuss that tonight. In case you haven't noticed, I've looked into it, okay? But this concept of the zoning officer isn't the one who can decide, gets a project comes in and says, that triggers site plan review. If he doesn't do it, I don't know that anyone else is trained to do it. But if that's, and I don't want you to lose that argument, you may be right. I mean, you're a smart dude. And we may go in and I may look at these definitions and look at our ordinance and say, oh man, that's really, that's right. I mean, he shouldn't be doing that. But I'm not going to make that's a big leap for me. I got to really know it's true. And like if you give me a Supreme Court case or something, but to go back and start looking at different sections of the ordinance and the definitions of the MLUL and the gaps in our ordinance, I need to know that's coming at me. I can't just do that now. I mean, I'll screw it up. I will. I'll either rule against you or rule for you. They're going to listen to me on this. It's not like that's a tight legal issue.
I'm just telling you that is one of two arguments. And like I said, and if you disagree with me, we're prepared to do.
I neither agree nor disagree. I plead ignorance. I mean, I have to have some heads up. I mean, that's not, I mean, I read everything.
I can just tell you, I'm not prepared to advise either of these clients to waive that particular argument. So if you're telling me that you're not going to proceed tonight, so be it.
Then that's what we got to do. I mean, I mean, you guys vote and you decide if you want to adjourn it, but I am telling you now, I cannot advise you on that with the information before me. I can't start flipping through, and that's a novel argument to me.
And I'm not
It's
saying,
in my knowledge, I think it's a novel argument that I never dealt with.
and it's an argument that only is within the confines of an application for a zoning permit. If someone walks into the zoning official with a project and says, do I need site plan approval? Can the zoning official make that opinion? Of course they can. That's not the issue, though. The issue, though, is whether or not the Chapter 417, which is your site plan ordinance, can be utilized as the basis for the denial of a zoning permit. It's a very narrow issue.
The issue is the fact that your argument wasn't included in the application
that,
materials,
yeah.
and he was not able to prepare. So therefore, I think the request is you table this so that he can prepare and correctly advise the board. So I don't think we need to hear any more argument. I think the board should
If it was
decide.
something that I should know, I would feel really bad about it, like if this was, some error. But I mean, at this point, I've seen most zoning things at this point in my life, and I've never heard that before, so, and there's no case.
I think you know me well enough to know that I would not advocate a frivolous position. to
I
this
don't, it could be perfectly right, I'm just hearing it right now, and I'm flipping around, like, reading the MLUL definitions of zoning permit, decide what a zoning officer can do, and I think it already sounds contradictory to me. I mean, I don't know.
The chair would like to recognize Mr. Ledwin.
Madam Chair, I'd like to put a motion on the floor to table these two applications until the board gets further information from legal counsel and the engineer.
Do we have a second?
How soon can we hear it?
Well, we could hear it in September.
I'll do it.
Let me see what the date is.
You can't say anything without going to the microphone and being sworn in. Go to the microphone. Sir, do you swear or affirm the truth of testimony you're about to give?
I do. just wanted to-
Identify yourself.
Oh, I'm sorry, Bruce Britton, zoning officer. I just wanted to point out, if you go to the code book and look under the zoning officer, what my responsibilities are, It lists the chapters that I am responsible for, and 417 site plan review was one of them.
Yeah, that's one of the things I would expect to find when I go and look into this, and
Okay.
that,
I just wanted
thank
to
you.
mention that.
Well, that didn't come up so far, but, all right, that's why I need time.
Okay, so, do you want to?
We have one motion, right?
Yeah.
Do we have a second?
Yes.
Yes.
Oh, did we have a second?
Yes.
Okay, who seconded, please?
I did.
Mr. Zexer?
Yes.
Mr. Ledwin motions, Mr. Zexer seconds. Mr. Ledwin?
Yes.
Mrs. Notch?
Yes.
Ms. Sheehan?
Yes.
Mr. Zexer?
Yes.
Mr. Yeager?
Yes.
Mr. Venuto?
Yes.
Mrs. Werner?
Yes.
Thank you.
How soon can we get them back? I don't want to delay them any more than necessary. Can we get them back? Now, I'll announce now, so they don't have to renotice, which is,
There's no notice involved.
No noticing on this.
okay.
I have September 25th. September 25th. Is that enough time for everybody to
Can you get me
file
something
what
on
they?
this? Like-
Yeah, I will, but I'm going to tell you it's not going to be next week or even before the 10th, because next week I'm starting a trial. My daughter's getting married next week, and I have an appellate brief due on the 10th.
I don't need a lot, any time before the meeting would be good.
We'll do.
Okay.
Can you just confirm the date? Do you have your calendar? Because I'm going to be bumping somebody from September to hear that, well, maybe two. I'll talk to the chair. We already have some, I haven't confirmed anybody, but just in case, I don't want to find out.
I'm good.
You're good? And the
Have
professionals?
an expert speak?
All good? Okay, thank you.
Okay, thank you for coming.
Thank you.
Thanks, Mr. Kaufman.
Sure.
You know, opportunity. I don't want to mess it up.
So, since those are use variance,
Okay, we,
Out of left field.
Well,
we need to approve the bills for Mr. Hurlis and Mr. King. Could we have a motion?
I'll make the motion.
second.
Mr. Venuto motions, Mr. Ledwin seconds. Mr. Ledwin?
Yes.
Mrs. Notch?
Yes.
Ms. Sheehan?
Yes.
Mr. Zexer?
Yes.
Mr. Yeager?
yes.
Mr. Venuto?
Yes.
Mrs. Werner?
Yes.
Thank you.
Before we adjourn, does any, or should we just adjourn? Speak about anything?
Point of information. I think before I could vote on this, I'd like to have
Oh,
some,
please don't talk about the application.
huh?
Talk about anything but an
Okay.
application. If you have something to ask me, you can ask me one-on-one afterwards.
All right.
But it's in a group, we shouldn't talk about it.
I thought I would just mention that the planning board shared, oh, okay, you go ahead.
Say that
You
too.
guys go ahead. Thank you.
Planning board listened to your recommendations. Mr. King was instrumental in recommending, with regards to the poll ordinance, was changed. They included a lot of language in there that specifies why we require what we do in that ordinance. So that should, in judging applications for pool setbacks and the requirements associated therefore, there are now reasons given in our ordinance. If the applicant's not meeting it, you can use that as justification for not voting for those, for that variance.
I was surprised, though. I thought we're going to work on not having pools in side yards. And I was surprised that didn't come up.
Side yard setback.
I know, but the HPC doesn't allow pools in side yards in the HPC area. And I thought we were talking about maybe not allowing that in general for pools to be in side yards.
So the board looked at the ordinance and felt that the setback and requirements were adequate as is. So we did reconsider those things, but it was determined from the planning board's perspective that the controls for pools was adequate as is.
If no one has anything else they want to bring up, we can get a motion to adjourn.
Motion to adjourn.
All in favor?
Aye.
Thank you, everyone. Good night.
What do we do with
Turn
this?
off. I guess we should save it, don't you think?